to take this opportunity to thank Malaysia HR Forum for organizing this AHRP program. I'm also very thankful for the chance to meet many wonderful like-minded people here throughout the program.
Okay, so I also remember about the advice from the CEO of Malaysia HR Forum, which is Mr. Kumar. He always says about AKS, attitude, knowledge and skill.
So first job, don't berkira-kira, work hard. The first 10 years of your working life, and what I've said the other day, the first 10 to 15 years of working life, it's all about hard work. So first job, grab what you can first, take it up, build your experience, build your competencies, learn the skills that you don't have today. The time will come when something will tell you that it is time to move on.
So you have to remember that having qualification doesn't really guarantee you a job, but it can land you with one. But for you to continue climbing the ladder, it's all about skills. And when we talk about skills, of course, not just soft skill, communication, writing, but relates to what you're doing.
What happened between that time until now? I never quit, never lie, and I never want to be somebody other than myself. So if you're a boring person, be boring. If you're an animated person, make sure that animation comes out. And if you're a person that is shy, so be it. The moment you lie, the moment you say you know things and you don't, that's when you won't get the job. At that rate, by the time you are 30, you're going to be having a salary of 7,000 ringgit. Congratulations. But 7,000 doesn't cut it in KL. Learn, continuously improve yourself. This AHRP paper is one of them. Continue to add stuff in your CV.
As a HR professional for many years, the AHRP program, the quality of candidate that we see today, they are well equipped with the confidence, the knowledge and skills of HR, what is it to be a HR person, and all of them coming from other background.
I'm very thankful for Malaysia HR Forum by giving us this opportunity to interview some candidates that they have trained in a 5 days program, and they also filtered the candidates based on their own requirements. And I would say that this is a fresh batch of candidates for us to interview. So it was good, and in a couple of days we will shortlist some candidates and hopefully to organize a second interview with them.
When I first saw it, I thought it was a really good idea to bring candidates together with a specific specialization, which is why I wanted to participate, because I've got HR needs that I'm looking for. So it was a good platform for me to meet a good pool of candidates who have a certification that I can work with. Some of them are meeting expectations. As an organization, I'm looking more towards the ability to communicate, looking at critical thinking, character and motivation of the people. So I think for the most part, I've met good people today.
Overall, it's a good experience to participate this HR Recruitment Day. And I think it's a very meaningful event that helps the fresh graduates out there to have the employment opportunity. Overall, I find the session very fruitful, and we managed to get a few good candidates, and we are going to shortlist for the second interview with our company.
HRD Corp, ladies and gentlemen, we are deeply honored to be invited as a strategic partner for this conference. This conference stands as a beacon of innovation and forward thinking, set against the backdrop of a rapidly evolving digital landscape that fundamentally alters how we work, interact, and grow. These systematic shifts brought about by the COVID-19 pandemic really have underscored the indispensable role of HR in navigating these changes, making our gathering here today more critical than ever.
And we like number of people yang datang, the event.
It's a very wonderful job done. Even till now, we've been part of many events out in the West and in Europe as well.
Having all this knowledge under one roof over 2 days is really useful.
I think the organizer has been doing a great job so far. I think everything else is good. The traffic is great. Yeah, we did enjoy our time here at the event.
I actually quite salute, with how they organize the whole thing, starting from the registration, everything is quite organized, in sequence, in line. And of course, they provide even food for everyone.
A lot of familiar faces. So dia macam nak satu big reunion macam tu.
If it's on again next year, we will certainly be coming back.
Scene here in KL is outstanding, and we hope to join you guys again in the next event.
Good afternoon. I hope you all are able to hear me and see me. If you're able to hear me and see me, give me a yes. If you're able to hear me, see me, just say yes, so at least I know everything's okay. Good. Okay. So welcome again, to the webinar today. So some of you all may have attended a webinar yesterday. So yesterday's webinar, we had a good webinar yesterday. And so today our topic is on managing retrenchment process. right? So it's going to be an hour and a half. So I'll be sharing with you how to downsize, the different approach to downsize, the difference between VSS, MSS, and of course, how to carry out the retrenchment process. So that'll be, the topic for today. My presentation will roughly take about 45 minutes or so. And then the other 45 minutes, we will do Q&A. So if you have any question, you can post in the various chat box. So this telecast, this webinar today, it is telecast via Facebook, LinkedIn, as well as YouTube. Yep. Okay. So the topic today is managing retrenchment process. But before that, I would like to invite all of y'all to join our HR forum. It's a Facebook page. It's a Facebook group of about 45,000. In fact, we are 50,000 yesterday. So the number is slightly outdated. So if you are not yet in our Facebook community, please click the QR code that you can see on the screen and do join us. And I would highly encourage all of y'all to get your subordinates. If you're in HR, get your entire HR team to join the Facebook community. Why is it important? Because in the Facebook community, in the Malaysia HR Forum Facebook community, we discuss issues, case reviews, what is the latest happening. We share templates, policies, guidelines. There are webinars like what you're going through today. There are webinars. We have also got free seminars. Now, all these are available in our Facebook community. So if you're already in, fantastic, good. I hope you found it useful. But if you're not in, please join. Please get your subordinates to join the community as well. And get your bosses to join as well. And so today's slides, the slides that I'm going to share today, we will also share in our Facebook page. Once the webinar is done today, we will save these slides. We'll share it in the Facebook group. Not page, sorry, Facebook group. So if you want a copy of these slides, get it from the Facebook group after this webinar today. Now, before I begin, I would like to run through one slide. This slide is more of a reminder. I think many of you would have seen it in my previous webinars. So let me repeat again for those who are new. So this one slide tells us this. Compliance is cheap. Non-compliance is expensive, right? So if you think compliance is expensive, try non-compliance. So what this phrase tells us, follow the law, because when we follow the law, it is much more cheaper, safer, faster. But when we try to be pandai-pandai, we don't want to follow the law, we take shortcuts, we try to, manipulate here and there, etc., thinking that we are all okay, everything's okay. Somebody else have done it, no problem. We do it. And if this goes to the court, and if the court finds that a company is wrong, then the penalty is much, much, much more greater. So in other words, if you think compliance is expensive, try non-compliance. Let me give you one simple example. In the morning, around 10 o'clock, on the day that you're not working, but it's, let's say on a Friday, you want to have a quick breakfast, you drive to the nearest kedai mama, park your car on the roadside, and you dash into the shop, have your makan, and you're back to your car. And you realize there's a summon on your windscreen. Now, if we were compliant, no summon, but because we were not compliant, now we got to pay the summon. Now, the ticket only costs us, if you put your parking coupon, it only costs us 60 cents. But because we choose not to be compliant, now we have got to pay 10, 20, 60, 100, depending on your town council, right? So, and it's going to be much more difficult to pay. It's going to take some time. But if we were to just open up our app, press a few buttons, activate the parking coupon, we can avoid the time and paying the fine, right? So I would like to repeat, if you think compliance is expensive, try non-compliance. It is a very costly mistake any company can do. So today's topic is very relevant to this phrase. When we want to retrench an employee, we find that this employee, we don't need him anymore. Now, can we retrench him? Is it really a retrenchment? Or are we cherry picking? We have got 30, 40 employees or maybe more than that. Why only these 3, 4 people? Is it really a pure retrenchment? Retrenchment means the business is not doing well, I need to downsize. Or that particular role we no longer have. The role has gone. We don't need him anymore, right? That is redundancy. Then you retrench them. But if you do not want certain person, then it is not retrenchment. But sometimes we try to use retrenchment to remove certain people. That is called cherry picking. And if this goes to court, you will be in trouble, right? So if you want to remove somebody, there are ways to remove it legally, lawfully, and safely, which we'll cover in the subsequent slides. So just to give you a little bit brief of myself, my name is Arul, and I'm sure you all have seen me. Some of you all have seen me. I would have seen you, etc. I've had a good number of years working, and I've decided to move on as a consultant, as a trainer. And today I'm attached to Malaysia HR Forum. And what do? I do advisory, we do consulting, we do training, we do a lot of webinars like this, to build capacity. So if any one of you all, if you are retrenching, you need some advice, you need some help. Some of it, we can't do free all the time. If you need paid advisory, you can contact me. My number is down there, 012-249-7342. My email is there, arul@malaysiahrforum.com. Or if you just want a quick answer, I've got this issue, what do I do? Please text me. You can WhatsApp me, right? I do reply WhatsApp. I do, I do pick up calls. I do reply email. Sometimes may be delayed, but I do. But please don't abuse me by, asking me again and again and again and again, right? We can't do this always because we are consultants. But if you want a one-off quick advice, if you want a quick input, that's fine with us. So now, when we talk about reducing workforce, right? Reducing workforce, there are a few approaches we can reduce. Retrenchment is one, VSS, MSS. I will explain later the difference between retrenchment, VSS, MSS in the subsequent slide. So the seminar today, right, the purpose of this seminar is to equip HR professionals or business owners or decision makers. How do you reduce your workforce? What are the strategies you can apply? How do we go about retrenchment process? What is VSS? What is MSS? Now, if you're going to retrench, there is a legal requirement that requires company to update Labor Department, or shall I say to notify Labor Department via Borang PK. So we'll go through that as well. And how can you offboard your employees? And what are the best practices? I will be sharing a couple of cases, right, that has happened. And we'll have some discussion as well. So if you have any question that you would like to ask, please type your questions in the chat box, right? Later part, my colleague will share with me and I will answer those questions. But please confine your questions to retrenchment. Do not ask on DI, do not ask on medical performance, etc. Because today's topic is this. Now, just to let you all know, for those of you all, if you're not aware, we have got a few more webinars happening next week and the following week. We have a webinar on minimum wage. Just like today is free. We have a webinar on minimum wage. We have a webinar on Sarawak and Sabah Labour Ordinance, right? We've got a webinar on definition of wages. What is definition of wages? How do you calculate overtime? So we've got a webinar on that as well. So if you want to join other webinars, please go to our website at www.malaysiahrforum.com. Go to the events page and look out for seminars and webinars. Sign up and you can join us. So we have got another 3 or 4 webinars, I think 4 webinars in the next 1 to 2 weeks, right? So yesterday we had 1, today is another, we have got 4 more coming, right? Make the best use of these webinars. And sometimes what you could do is get your decision makers. For those HR, if you're listening in, sometimes the bosses don't trust you, right? Or sometimes the bosses wants a second opinion, right? They yes, agree, I agree with you, but can I get a second opinion? So what you can do, and this is what many companies are doing today, they know when the webinar, they book a meeting room, they invite the HODs, come, sit down, listen, right? So they may not trust you at times, but they may trust an outsider like me, right? So make the best use of these webinars. It is free. Get your team together. Make it as a learning exercise, right? You should be allocating certain hours of your work hours to learn. So this could be one approach. So the upcoming webinars, if you can, get your HR team members, block their time, ask them to come for 1.5 hours, listen to these webinars, right? I hope to see you more in the upcoming webinars. Now, there are multiple ways how to reduce workforce, right? How to reduce the workforce. You can take multiple approach. So I'm just going to go through briefly, then I'll go through one by one, the subsequent slide. So we have got attrition. Attrition is one, right? When somebody leaves the company, you don't replace. That is one way of reducing your workforce. So when we say reduction of workforce, it is not necessarily paying them money and asking them to go, right? Attrition happens. When attrition happens, do not hire, right? You can also reduce your work hours or talk to your employees, see whether anyone is willing to consider to convert their employment to part-time, right? So converting the part-time is one option, right? Instead of you removing them, maybe, for example, if I'm a, let's say if I am a production exec, but because your volume is dropping, right? Your production volume is dropping, you don't need me 100%, but you need me maybe 50% of the time. So why not convert my contract? Of course, you cannot force the employee. It has got to be mutual. Talk to the employee. Business is not so good. Can we convert you to part-time? You come only 3 days a week. The other 2 days, you do whatever you want. At least you can go and do something else to make some extra cash because business is not doing well. So you don't have to necessarily retrench all the time, right? Reduce work hours or talk to the employee to see whether he's agreeable to move into part-time for the next 3 months or next 4 months or whatever the period is. You can also do outsourcing. You can also, that means you get workers from another organization, or another concept is workforce leasing, or offer VSS. I think many of you all are very familiar with VSS. In another context is, if there is a vacancy, don't hire. You freeze the hiring. Job sharing, 2% do one person's job. Reskilling, redeployment. For example, instead of hiring additional person and adding on your headcount, business not so good, I want to actually reduce and not rehire. What you can do, if you know that somebody else is available and is not fully utilized, deploy him to another area if you can. Automate, upgrade your technology, offer MSS. Many of you are very familiar with MSS. You can even talk about early retirement. Talk to those employees who are already reaching 60 years old, those who are at 57, 58, 59, for example, see whether they are open to the idea to retire early. Now, of course, if you're thinking, oh, like that no need to pay. Of course, got to pay. But you can, you can discuss and negotiate a package so that they can go earlier. You still save money. Otherwise, you end up paying them salary for the next 2 years, for example. Temporary layoff, you lay off them for time being, and when business becomes good, you bring them back again. Or close your business unit, close your department, close your organization, or you do corporate restructuring. Now, the other option is performance-based reduction. I'll share with you in a short while. And I think retrenchment, you already know it, right? So VSS, MSS, retrenchment, you are very familiar. There is a difference between these three, VSS, MSS, retrenchment. I will share it in a short while. Now, let me run through, all these workforce reduction strategies, but I'm going to run through very briefly. You have this copy of the slide. You can read it later to have better understanding. Now, attrition means what? Employees leave your organization. So, attrition happens, right? They found a better job, better offer, they go. Right? This is very common. So if you know that the business is not doing well, why do you want to hire? Sometimes, what puzzles me, some organization, business has not been going on well for some time. But when they have a new job, or maybe somebody has left, they quickly hire someone. Why do you hire? If you know business not doing well, and there could be a possibility of you going through a retrenchment exercise, why hire? Right? You freeze your hiring. Right? You freeze your hiring, or you offer early retirement. So let's say now I've got an employee, he is 58 years old, right? If I were to continue employing him, I will have to pay salary for another 2 years. But what I could do, I could talk to the employee, hey, would you like to retire early? We can work out a package. If he's going to continue working, you're going to continue paying 2 years salary. But you can negotiate with him. You cannot force him, but he can negotiate. Would you like to retire early? We are willing to pay 1 year's salary as a retirement thing. So it has got to be voluntary. You cannot force them, right? That's retirement. The other option, I spoke about part-time. I want to just touch about part-time. Sometimes those employees who are going to retire, you do not need them 100%. You probably need them for maybe 25% of their, 25%, because they can do certain job that others cannot do. The other option is those who are approaching retirement, convert them into part-time job. That means they just have to come 2 days a week, 3 days a week. Of course, when you do part-time, the salary also reduced because your work days, your work hours also reduce. That could be one option. Now, these are methods that people have done. So retirees, instead of you trying to see what can I do, he's got 2 more years, talk about early retirement, right? Work out a package for early retirement, or convert them into part-time. Maybe they want. So I handle a case personally for one of my clients. And this particular employee, I suggested to the client, why not speak to the employee? I asked them this. The question thrown to me was, this employee is 50 years old. Can I retrench him? I do not want him anymore. So I asked the company, is there any job that only he can do? You have not found a successor yet. They say, yes, he's doing certain things. Why not talk to him on part-time employment? They say, Ken, is it possible? I told them, yes. So what I did, I arranged for a meeting. I told the employee, look here, the company, is able to convert you. In other words, the company do not need you full-time. They don't need you full-time. They need you to perform this job. And this job only takes about 2 days a week. Are you open to the idea to convert your contract from a full-time to part-time? Then the next question he asks is, so what's my salary going to be? Your salary will be reduced 40%. So in other words, whatever he earns today, he will only get 60% of his salary. He said, oh, it's possible, huh? I would like it. So he was keen on it. So we told him, if you're keen, can you inform us in writing that you would like to convert to part-time? So he wrote into the company replied, agree on the terms, he signed the contract, done. Right? He's happy, company's happy. Sometimes your employees may be waiting, right, for things like this, especially if they're approaching retirement, because for some retirees or for some employees who are going to retire, money is no longer their motivation. Right? Some of them, yes, they need money. They may not agree with you. But some of them, their kids are grown, house loan is paid for, car loan is paid for, kids' studies all done, etc. They're just working to keep themselves occupied. They might be open to the idea to convert into part-time. By the way, full-time, part-time, it's all regulated, covered under Employment Act. Reduction in work hours, or, like I said, convert to part-time, that's one example that I gave you just now. The other option is, some of your employees, you will be surprised, right? You'll be surprised. Some of the employees that we have today, many of them are having second job, third job. They are working for you full-time. They could be driving, Grab. They could be doing some other, work which doesn't conflict with their job in the office. Now, some of them also would be open to the idea, would you like to, we want to reduce work hours because business no good, right? Of course, when we reduce work hours, automatically your work is reduced, your pay is also reduced. But during this period, you can do whatever you want, provided it doesn't conflict with the company's, whatever job that you do. They might be open to the idea. So this is one option you can consider. Job sharing. You've got a job, but you don't need a full-time employee. You can even ask 2 existing employees to take over this job. That means you split this job, ask 2 person to do. This could be another option to not increase your headcount and not hire new employee. Temporary layoff. Now, during COVID, I think this was one of the major, activity, or shall I say, one of the big options taken by companies to lay off people temporarily for a period of time. Because why? The business not so good in the next 2-3 months. So we lay them off temporarily, and once things are good, we bring them back, right? This could be done. Some of you all may be familiar with the term furlough, right? Furlough is a concept, not so applicable in Malaysia, but what they do, they bench these people, just ask them to sit, bench them. They even pay salaries, some of the companies also pay salaries during this period, some don't pay, right? These are one option. Unpaid leave is possible as well during retrenchment. If, let's say, company business is not good, there's no work provided, you talk to the employee to go on an unpaid arrangement. That is also another possible option. Outsourcing, right? Outsourcing the position. That means what you do is certain processes that you have, you outsource to a third party. like some MNCs, right, some of the big organizations, they have outsourced some of their processes. Even payroll, for example, instead of hiring a payroll exec to do a payroll, to do your payroll, they outsource payroll to organizations that do payroll services, right? You can outsource your processes or job functions. Reskill deployment, I think many of you are familiar. If business not so good, close your business unit and retrench your employees. Workforce leasing, this is quite common. Sometimes you also call it outsourcing, right? We may change the labels interchangeably, but workforce leasing means what? You get temporary workforce from another agency. For example, Manpower, Kelly Services, Edeco. You get temporary workforce from them for a period of time, and you let them go, right? This is also quite common. Or you upgrade, you automate your processes, right? Automate your processes. Some organizations, they've automated processes which can reduce headcount. Recently, a couple of weeks back, the plantations minister says that now in the plantation, in the oil palm industry, right, there's a technology that can reduce 30% of workforce, right? So automation, making technology upgrades to your workplace, to your processes, etc., can also help to reduce manpower. Now, performance-based reductions. Now, here, you use performance evaluation to determine who you want to keep, right? Of course, poor performance, all organizations want poor performers, those employees with disciplinary issues, etc., to go. But do this very carefully. This can be done via VSS, MSS to be done carefully. So VSS, MSS, I'll cover the concepts in a while, but in VSS, MSS, you are not forcing anyone. You make the offer, they come, you agree, they agree, both parties are happy, they go, right? So you can do this via VSS, MSS. So if you have a poor performer and you do not want this person anymore, how do you manage them out? If the business is not so good, you can't retrench them. You can talk about a package, you can go on a mutual separation, or put him on PIP, go through the PIP process. At the end of PIP, if he cannot perform or she cannot perform, then you terminate them on the grounds of poor performance. But otherwise, mutual separation. VSS, voluntary, this is a very familiar term. So VSS means the company is not doing well, the company makes a general offer. We tell employees, okay, business not doing well, we are offering 1 month per year of service to anybody who wants to go. So if you want, you write into the company. So if they write in and you're okay for them to, you're okay with this employee, you do not need his services anymore, you grant him the VSS. Of course, there's some processes to be done, and he goes, right? That is VSS. MSS, you can talk to a particular employee, right? And the employee, you don't have any more plans. There's no plans for this employee. He doesn't fit your long-term plans. Talk to the employee saying that things are not working out. We don't have any plans for you. The company would like to talk to you on a mutual separation package, right? Are you prepared to consider a mutual separation package? But employee here can demand, because it has got to be a sweet offer. You cannot force it on him. If you're going to offer the minimum 10 days, 15 days per year of service, to me, that is not sweet enough. Why should I take 10 days, 15 days, 20 days? If the offer is sweet, yes, I would like the package, I can sign, I will go, right? So mutual separation, the incentive must be attractive and must be mutual. You cannot force it on them. Same goes to VSS. VSS, you cannot force it on them. But usually VSS, the common arrangement out there are many companies pays 1 month per year service, but some may offer lower. But there are also organizations that offers 1.5 month or even 2 months of their salary, right? But this is general. Mutual separation is on a one-to-one basis. Retrenchment, right? So VSS, MSS, retrenchment. Now, retrenchment is where it is mandatory. Everybody's got to go, or a department's got to go. No negotiation, right? You got to go. Whereas VSS, MSS, if the employee do not want to go, you cannot force them. But retrenchment, there is no options available for them to say, I don't want. Why? Because your department closed. Your job disappeared, gone. You are going, this is the package, but this is the payment. But you got to be careful when you do retrenchment. If your retrenchment is genuine and no cherry picking is done, your retrenchment is safe. right? Of course, you follow last in, first out, and all those things, right? So these are the three common ones that many of you all are familiar with. Now, layoff. This comes from the Regulation 5 of the Employment in bracket Termination and Layoff Regulations 1980. So what is layoff? So layoff means the employee is no longer required, you lay them off, right? So it's quite wordy. I am going to leave this to you, but let me just highlight one point that is in red. Now, if you do not provide work for the employee, right? He comes to work, or you don't provide him work of at least 12 days, right? 12 normal days, within the period of 4 consecutive weeks, right? And the employee is not entitled to any remuneration, during this period, then he's considered to be laid off, right? So just take note of that. So you got to provide work. If an employee is prepared to work, you got to provide him work, right? That's your obligation as an employer. Okay. And Regulation 3 says that any employee, they will not be entitled to termination benefit, right? There's a termination benefit that you need to pay if you're going to remove an employee, if you have offered him a new contract, right, to re-engage him. Now, if you have offered a new contract, you don't need to pay. But if the employee refused the new offer, right, if the employee refused the new offer, then that is their fault, not yours, right? So this comes from the Employment Termination Layoff Regulation 1980. You will not find this in the Employment Act book, right? But this is an extension to the Employment Act. So I hope you all have a copy of the Employment in bracket Termination Layoff Regulation 1980. If you don't have one, you can visit the Labour Department's website. You can download it from there, or you go to the HR forum and you search for Employment in bracket Termination Layoff Regulations 1980. You'll get a copy of this as well. Now, if you're a HR practitioner listening in today, these are the documents that you must have, right? The Employment Act, Employment Act, Trade Unions Act, Industrial Relations Act, Determination Layoff Regulations, Part-Time Employee Regulations. So there are many other regulations, limitation of overtime regulations, right? So these are the regulations that you got to have. Another important regulation that many people do not know of, Employment Regulations 1957, right? If you have a paper and pen with you, write this down. Employment Regulations 1957, right? Now, in this employment regulation, it says that you must maintain a maternity register if a female employee is going to go on maternity. Pay slips, hard copy or soft copy. Pay slips has got to be in English or Bahasa. Your employment terms has got to be English or Bahasa. Now, all these are covered under Employment Regulations 1980. So download it, read it, and if you need to make some changes to your processes, your policies, your documentation, please do it. What is retrenchment, right? Retrenchment means, right? Retrenchment means termination of the employment contract or the contract of service because either the company business is gone, they're going to close the company, or it can be a department that is affected. This department, you have outsourced the department, or the department no longer required, or that particular employee's job no longer required. So it can be a company as a whole, it can be a department, it can be a small section of the company, or it can be 1 or 2 jobs. But remember this, no cherry picking. You cannot just say, that employee, right? That is called cherry picking. Why that employee? If the job is still there, if he's still performing, the job that he or she is doing, if the job is still there, the job has not disappeared, how can you retrench him, right? But if you're going to pick certain people here and there, on what basis? Now, when we look at all the past cases of retrenchment that has gone to the industrial court and what the court has reviewed and advised, if the retrenchment is genuine, the job really disappeared, not that I don't want him, but the job disappeared and I can't afford to keep him. There's no reason to keep him. I do not have any other job anywhere to put him. Then you retrench him. But if you're going to cherry pick, this guy, he's been here too old, salary is too high, I don't want him. I'd rather have a young guy. Now, that is called cherry picking, right? Which I would advise you to think twice before you do that. It's best not to do it. Retrenchment and redundancy, or shall I say redundancy and retrenchment. Now, if you know that the business is not doing well, you got to take some early actions, right? Take actions early and not last minute oh, business no good, I want to retrench. There are some expectations that is on your shoulder as an employer. There are some prerequisites. Before you retrench, what should you do? Now, A, B, C, D, E, F until I, right? All these are taken from two documents. Number one is the Code of Conduct for Industrial Harmony. Now, this is a code between MEF in 1975 and the Ministry of HR in 1975, or was it 85? I can't recall the date. I think 75. They, the ministry and the Employees Federation at that time, they have come together. They've agreed on some principles, how company should operate, how company should, how company should promote industrial harmony, right? Now, if you want a copy of the Code of Conduct for Industrial Harmony, I'm not sure where else can you download, but I know you can download from the Malaysia HR Forum Facebook community group, right? If you want a copy of this, go to the Facebook community, you type Malaysia HR Forum, you type Code of Conduct for Industrial Harmony, you'll get this document. And the other document I've referred to draft this out is the guideline on retrenchment by the Labour Department, right? You can download this from the Labour Department's website, or you can also get it from the HR Forum. So I've compiled, all the, the prerequisites that you should do, that you should take note of before you retrench. Number one, if you know the business not doing well, limit or freeze your recruitment. Unless there are some critical areas that you must hire, then you go ahead. But generally, you freeze recruitment. You restrict or reduce overtime. You restrict or limit the number of, weekly, work on weekday. Restrict or limit of work on weekly day of rest. That means sometimes you may call employees to come on their rest day. Limit that, right? You can even reduce the number of work days, reduce the number of shifts, right? Reduce number of hours of work. So you reduce, you're still saving a job. End of the day, the objective is, can we take any other approach in order to avoid terminating somebody or retrenching somebody? Save the job. Lesser pay, but the job is there, right? So reduce number of hours of work, retrain your employees, reskill your employees, so that they can do other activities, other job, other tasks, right? Over and above theirs, or move them to another area. Identify any alternative job. If you're going to retrench somebody, right, what this particular division is not doing well, you want to retrench somebody. Now, before you retrench this person, you should also explore, are there any other jobs in the company, any other department that he or she can be transferred to, right? So alternative jobs within the same company, within a subsidiary, and so on. Even if the pay is going to be reduced, right? Document it. Or implement temporary lay them off. When things are good, you bring them back, help them to get an alternative employment if you can. There are some organizations, which I would take my hats off to them, because they are very responsible, and they do not just want to, so-called dump the workers just because business no good. What they do, they reskill them, they run some classes for them, help the employees to prepare resumes. They even find another job for them to work temporary. Once business is good, they say, hey, you can come back now, right? You can do that as well. That is what I call as a very responsible and a caring employer. Or if really business is so bad, you need to do pay cut, right? Which happened during COVID. If you all remember, pay cut, no job, etc., or business bad, you can do pay cut as well. But I would advise you to do pay cut as a last resort. And of course, finally, retrenchment. So before you retrench, consider implementing A, B, C, D, E, F, G, H, I, whichever is possible, practical, and helps you to reduce your costs. Now, remember this, retrenchment cannot be done for cost reduction purposes, right? You can't do retrenchment to avoid cost avoidance. Okay, you know what? I think business is going to be affected, down the road. Let's reduce. Now, you can do cost reduction, but not at the expense of affecting an employee's job. Okay, so I would encourage all of you all to download the Code of Conduct for Industrial Harmony and the Guidelines on Retrenchment Management by the Labour Department. You will find these two documents very useful if you're going to carry out, because it gives you some good guidance what to do and so on. And just to point out, item G, H, and I, right? Alternative job, temporary layoff, pay cut, right? You must get it in writing, right? If there's a trade union, it is good to discuss trade union, inform them what is going to happen, right? Sometimes it's good to work together the union so that union understands your situation. They are also employees. They understand the situation. Sometimes union can also help to disseminate the info. They can help to tell the employees, business not so good. Let's support the company this time. So retrenchment and redundancy, the ultimate responsibility to decide your workforce, how big your workforce should be, right? It is up to you as an employer, right? The court has acknowledged this. The right to reorganize the business is up to the employers. But before any decision on reduction is taken, you must have consultation, right, with the workers or the trade union. I mean, it's fair, right? When we say stakeholders, we need to talk to our stakeholders. Employee is one of the important stakeholders. Management, employee, your supplier, these are all your stakeholders. So one of the very important stakeholders in your organization is your employees. So if you're going to downsize, don't you want to talk to your stakeholders? Talk to them and so on. So the Code of Conduct for Industrial Harmony, says this: the responsibility to decide is on you. But before you make a decision, right, or to reduce the workforce, there must be there should be some consultation. That means some discussion with the employees, with the union, if there's a union. To me, this is a very fair statement or very fair request. So now, again, I would like to just run through the process, right, before you retrench. So number one, right, take whatever measures you can. For example, we said reduce work days, reduce work hours, reduce overtime, reduce shift, maybe cut all your business expenses, don't do team building, avoid annual dinner, etc., just to reduce costs. But once you've done all of those things and you still cannot sustain financially, so what do? Then you may have to do these particular steps. Number one, you give as early a warning as practically possible. So, give your employees information ahead of time, not last minute. Okay, ladies and gentlemen, business not so good. Next week, we're going to retrench all of you all. Now, for them to get another job is not going to be easy. Today, I mean, if blue collar, maybe the job, it's quite easy. You walk in any retail outlet, you walk in any restaurant, factory, maybe they can take you instantly or maybe within a week or two. But if it's a blue collar, if it's a manager, a supervisor, now for them to secure another job, it's not a matter of 1-2 days. It may take a few weeks, maybe a few months, right? So when you give them advance information that, guys, business is not so good, company may be doing a retrenchment exercise down the road, right? So this also mentally prepares your employee. It's fair, right? Just like all of you all, when employee wants to resign, you will tell employees, give me a notice. Why do you have notice period? So that company can work out other options, quickly find somebody new, etc. So if you're going to remove your employee, give them an advance notice so they can prepare themselves mentally, financially, and they can start, planning out what should I do if things go south. Number two, introduce schemes for voluntary retirement or voluntary retrenchment or retirement. That means if business not so good, you offer to employees, business not doing well, we like to offer VSS for anybody who wants. The package is 1 month per year of service. Or those who are retiring, we are prepared to work out an early retirement package. Number three, give termination or notice, right? Based on the notice period. But if your notice period is less than 4 weeks, 6 weeks, 8 weeks, for retrenchment, you got to follow the minimum 4, minimum 6, minimum 8. So some contracts, the notice period is 1 week. So does that mean if I'm going to retrench, I give a 1 week notice? Answer is no, right? EA says this: if the notice period is absent or if it's less than 468, you got to follow 468. And terminate the contract of service for those people who have attained the retirement age. If they've already retired, they are one of those that should go. Apart from foreign workers, they are one of those that should go. Now, if needed, talk to the authorities, right? Tell them that you're going to go through a retrenchment exercise. Sometimes the authorities can also help you out. And I know of, for certain fact, and in some cases, Labor Department, even per queso to some extent, they do have some, some help they can provide to you. So talk to the agencies, talk to the government, departments. Number 6, you spread the termination employment over a period of time. Instead of terminating everybody within a short period, within a month or two, etc., you can also spread this over the next 6 months or so. Some companies do that. Those employees who are critical, crucial, they'll keep them till the last day. And of course, if you're having a union in the organization, it is best to talk to the union, inform them, consult them before you make an official announcement. So where is all this provided for? It is not something that I've cooked up, just plugged from here and there, ChatGPT. No. All these 7 points comes from, number 1, the Code of Conduct for Industrial Harmony and the guideline on retrenchment management by the Labor Department. So that means the authority, which is in this case Labor Department, has given, I would say the guidance is quite clear enough. It may not be very specific, but I think the guidance are quite clear enough for you to plan out your subsequent steps. And again, this came from the same 2 documents. Now, when you want to retrench an employee, how do you go about selecting who to go? Who should I retrench? So from the 2 documents, it says this. Now, when we want to retrench an employee, you must have certain objective criteria. There must be some criteria. So the criteria, you must think of it. If there's a union, talk to them, consult them, etc. if needed. Number 1, the need for the efficient operation for the company or whatever business you're doing to continue operating, right? Some positions you do not need, some positions you still need, etc. You can also look into the ability of the person, the experience, the skills, the qualification that is required for them to continue working. So let's say now I've got 2 employees. Let's say I take 2 technicians. I've got 2 technicians. One is an older technician, has been with the company for the last 20 years. And I've got another technician, he is new, just joined the company about 2 years ago. One part of Code of Conduct for Industrial Harmony says that the last in should go out first. So last in is the guy who came 20 years. But this employee who's 20 years, has been in the company for 20 years, he is managing certain machine that is already outdated. We no longer have this machine. But this new guy, the previous guy, the 20-year-old, the guy has been there for 20 years, he do not have a paper qualification. He's a rank and file employee. Whereas the new chap with 2 years experience, he's got a diploma. He's very good mechanically. He's very good with mechanical components, and he can troubleshoot machines, even the latest machine, which the older guy cannot do. Now, on that basis, you can remove the older chap and keep the younger chap. You can do that. On what basis? Because of skills, qualification, and so on. Right? So that's what point number 2 is trying to say. Or you can also look at, length of service. EA says that when it comes to termination, foreign workers go first. Right? That's given. So foreign workers, your casual workers, your temporary workers, etc. So those older employees, by right, they should go first. Last in, first out. So those who came in, sorry, not the older workers, made a mistake. Last in means the newer ones go out first. Last in, first out. So whoever came in last, go out first. That is last in, first out. And of course, family situation. This is a bit tricky. Or any other criteria that may be formulated in the context of national policies. Right? If you're going to retrench an employee, you should give them priority to be re-engaged, right? If it is possible. Sometimes business not so good, you rehire them back. So I remember Tony Fernandez, CEO of AirAsia, just in a couple of months back, there was a video by him. He says that all the employees, the crew that they laid off, they hired all the crews back. Now, this is what we call as you retrench them. If business is good, you re-engage them back. So AirAsia proudly says that they've re-engaged every single headcount they laid off. I mean, based on the video. I hope I got it right. So let's look at Section 60N, right? This is an Employment Act. What it says is termination of employment on the reason of redundancy. So what it says here, the employer shall not terminate the services of a local employee unless he has first terminated the services of foreign employee in the same capacity, right? If both are operators, both are engineers, same capacity, same job function, same job grade, etc., then the foreign employee has got to go first. So FWFO means foreign workers first out in the same job category. If it's two different category, that's a different story altogether. But if in the same job category, the foreign workers or the foreign employee goes out first. Now, the other one is last in, first out. This came from the, what do you call this? Code of Conduct for Industrial Harmony. It says that last in, first out, right? Implement the principles of last in, first out. So the last employee was hired. In other words, those junior employees in the same job category, not different category, but in the same job category. Let's say two sales engineer, both are sales engineer, same job same job category, both are same grade, same job. One has been with the company for 5 years, one is for 2 years. So the 2 years need to go first. But for some reasons, if you feel you want to keep the guy with 2 years experience, but the 5 years you want him to go, you must have a valid reason why you're not following last in, first out. Though there are a couple of cases that has happened in the past where the company deviated. That means they did not follow last in, first out. Deviated from last in, first out with proper reason, convincing reason, the court says, okay, right? So if you do not want to follow last in, first out, you must have a valid reason why you departed, why you did not follow last in, first out. So I gave the example just now, the 20-year-old chap and the 2-year-old chap. The 20-year-old chap don't have a paper qualification, rank and file, and he can only repair old machines, right? The young chap, he has got a diploma. He is very good, with electrical work or mechanical work. He can repair all these new machines because he's highly trained. He's got a diploma. Now, I'm going to keep him and I'm going to remove the older employees. So in my view, that would be an acceptable reason. So can we select an employee to be retrenched based on performance and behavior, or performance and behavior? So it's not about age, it is not about years of service, it is not whether the job is redundant or not, etc. But we select based on performance or behavior. So what do you think? Can or cannot? Boleh ke tak boleh? Now to answer that question, right, let's look at this case, right? This is a case of Neo Wiming versus AirAsia. This was a case in 2023. So in this case, right, the company applied so-called a best fit criteria, right? This was in the papers, a best fit criteria. So the best fit criteria took into account the employee's special skills, qualifications, performance rating, disciplinary records, as well as salary and years of service. So this was the so-called best fit criteria. Now, in this particular case, the courts accepted it. The court says this is okay. I mean, in other words, the decision by the company was accepted. So the court says this, it's a tried law that the Code of Conduct, CCIH means, and this was cited in the case, CCIH means the Code of Conduct for Industrial Harmony. It does not have the force of law. That means it's not a legal document. It is a guideline, right? It's just a code, where it requires company to practice last in, first out. So in this case, right? In this case, other cases, but in this case, the court says that last in, first out principle is not mandatory for retrenchment exercise. But nevertheless, employers must provide strong and good reasons for not applying the procedures and retrenchment provided in the code, right? The court says this. So it is, if you want to depart from last in, first out, you must have a valid reason why you departed, right? So that was the case of AirAsia, where the company applied the best fit criteria. Now, let me run through the difference between VSS, MSS, and mandatory retrenchment. Now, for those of you who just joined in, these slides will be shared to you via our Facebook group. So after the webinar today, we will save these slides in Facebook group. You can download it. Now, let's look at what is the difference between VSS, MSS, and mandatory retrenchment. So I'm going to run through one by one so that we are clear to avoid any confusion, right? If you have any questions, please ask the questions in the text box. I will answer these questions, at the end of my presentation. Now, VSS, MSS, and mandatory retrenchment. So VSS is voluntary. V, voluntary. MSS is mutual. Retrenchment, the reason I added the word mandatory, because in retrenchment, employee has no say. If the department is gone, you go. The job is gone, you go. The business is going to close, you go, right? No options. But VSS and MSS, right, it is not compulsory. If the employee says that, no, I want to continue working, I tak nak pergi, I want to work, okay, you cannot force them. In mutual separation, hey, you know what, the company do not have any plans for you. We'd like to offer you some package. Are you prepared to discuss? Are you prepared? Now, that is mutual. If the employee says, no, I don't want to go, you can't do anything. But in retrenchment, he has no options. He's got to go, right? So can the employee choose not to participate? In VSS, MSS, yes, he can say, I don't want, I want to work. But in retrenchment, answer is no. And if you're going to retrench this employee, if they are earning wages up to 4,000 ringgit, or if they are manual labor, if they are supervising manual labor, they are entitled to the termination benefit provided for in the regulation that I mentioned just now, which is 10 days per year of service if less than 2 years, 15 days per year of service if more than 2 years, and 20 days wages per year of service if they work for you for more than 5 years. So 10, 15, 20. So you got to follow. You can pay more, but you cannot pay less than 10, 15, 20. So for VSS, MSS, if you're going to pay 10, 15, 20, not attractive, I don't want. Not much. So VSS, MSS, it has got to be attractive. If you're going to pay minimum, I don't think all of you will take it. So if you don't want to take it, you think employees will take it? Right? So I don't think any one of us would accept 10, 15, 20 if it's VSS, MSS. But if the employee says, no problem, you pay me 10 days or 15 days or 20 days per year of service based on their years of experience, years of service with you, if they accept it, fantastic. Well done. You are a good negotiator, right? But if the employees refuse to accept, there's nothing much you can do. So VSS and MSS, the amount, the package you offer, in my view, and I can tell you it's a logical common sense, it has got to be attractive. But in a retrenchment exercise, there's no negotiation. You don't need to negotiate because why? They have to go because the department gone, the job gone, the company is closing down, right? In a retrenchment, yes, you can pay 10, 15, 20. But we know there are mixed practices out there. There are small companies or those who can't afford, they pay 10, 15, 20. Business already not so good. I don't have money. But we also know companies like some of the GLCs and MNCs and PLCs and some SMEs, who can afford, they pay 1 month per year of service. Or I know of a company, they pay 2 months per year of service, or 1.5, 1.25, etc. So it's up to you. The minimum has got to be 10, 15, 20. But if you want to pay more, that's up to you. Can you force an employee to accept VSS, MSS? No. But retrenchment, they do not have an option. So if they don't want to accept VSS, MSS, what do? They continue work as usual. You cannot force them, right? Because it's voluntary or mutual. But in retrenchment, the moment you retrench them, they have no option, they got to go, right? Now, in all these 3 cases, whether it's VSS, MSS, or retrenchment, do you need to notify Labour Department? Answer is yes, right? Even though if you look at Borang PK, it's, the word MSS is not there, but clarification was done. Labour Department says that even for MSS, you must tick you tick the VSS box. You must still submit the Borang PK. So Borang PK is not an approval. Submit to Labour Department, wait for them to say boleh ke tak boleh, yes or no. No. This form is merely to notify pemberitahuan. You notify Labour Department. Of course, Labour Department, they may call you up, they may want some info, they want some documents, that is their rights, right? So, but you got to notify the Labour Department. Now, if I'm going to pay my employees because they're going to lose their job, right? There's a loss of employment. Can they get any tax relief from tax department? Yes. Our LHDN regulations also gives tax relief if you're going to pay them a retrenchment or termination benefit. right? There's some formula, 10 days, 10,000 per year of service or something like that. Do they also qualify for the job search allowance? You know, all of y'all, if you're working, the company is paying, you are paying, the company is paying for SIP, right? So if the company retrenches you and you got a letter of retrenchment, you can qualify for the 6 months job search allowance provided by Perkeso SIP, right? For all these cases. So this is a general, difference between MSS, VSS, and mandatory retrenchment, right? Like I said, some people ask me, why do you have the word mandatory? I mean, I always tell them this: retrenchment means it's must, you got to go, no negotiation, as compared to VSS and MSS. So who qualifies for termination benefit? Now, this could be some, confusion that you may have. Those people in the red box, right? Now, those of you all, if you want to understand this table, I've got a webinar coming up, which is called the the Employment Act Amendment. Please join that webinar. I will run through in detail what this table says. This is basically a summary of the first schedule. So who should you pay termination benefit? You got to pay to those people in the red box. Who are those in the red box? People who are earning above 4 and who are not a manual labor. So in other words, right, if you have a technician, lorry driver, and they're earning 5,000, 6,000, a supervisor who supervise manual labor, if they're earning 8,000, even though they're earning 8,000, because they are manual labor or they are supervising manual labor, they also are eligible for termination benefit. So it's not just above 4 means I don't need to pay. That is incomplete statement. If it's a HR manager, above 4, no need. If it's a, let's say, a production exec, above 4, no need. But if these people are manual labor, or if they are looking after operators, doesn't matter what the salary, if you have a crane driver earning 10,000, he is also eligible for termination benefit, right? So if you want to know this table more, join us in the next webinar on the Amendment to Employment Act. So now, these are wages. I'm not going to cover this. I'm just giving you some additional slides, for you to understand what is wages, how to calculate. Now, when we talk about termination benefits, right, how do we calculate the 10 days, the 15 days, the 20 days? So we need to take the actual wages paid to the employee in the last 12 months. Or, sometimes we say true wages. What was actually paid to them, right? The true wages. So we take the basic salary, allowances, except transport allowance, overtime, commissions. So these 4 items that they've earned in the last 12 months, you take all these items, but you do not include bonus. Any bonuses paid, you do not include. So should I include traveling allowance? Right? Okay, actually I made a small mistake here. The item B, right? Except traveling allowance, not transport. Transport you got to pay. So a small typo, I hope I will update the slide. So when you download it, I'll correct this. So except traveling allowance. Traveling allowance is not wages, right? Why? Because if you go back to section 2, right, you can see here, item C, wages, right, does not include traveling allowance. It excludes traveling allowance. So here, basic salary, all allowances except traveling allowance, overtime and commissions, all these are included, right? Bonuses, answer is no. So once you have calculated what was the 12 months true wages, then what you do, the 12 months true wages, you divide 365, you get 1 day salary, right? Then you determine how long has this employee has worked. So you take the total employment period in days, divide 365, you will get whether 10.5, 12.2, etc. So once you've got that, then you multiply by whether it's 10 days, 15 days, 20 days per year of service. So let's say, for example, the 1 day wages is 200 ringgit, for example, and the employee has worked for 10 years. So what do you do? What do we do? We take 200 times 10 times 20. 20 days per year times by 10 years times by 200 ringgit. You will get the termination benefit. Okay. And if you are going to ask them to go immediately, you also have to pay them the notice period. You also got to pay them the annual leave that they have not used yet. right? These are the payments you got to pay. And remember this, LHDN requires you to ensure the clearance is given by them before you make the final payment to the employee. So otherwise, you're going against LHDN's regulation, you will not the employee will not qualify for the tax relief. So for this scenario, yes, you got to get LHDN clearance first before you release the termination benefits. So these are the components. So what do we do? Again, I made a typo error there. It's not transport, it's traveling. So the component of true wages, basic salary, allowances, except traveling allowance, overtime, commissions. So what is not included? Transport allowance not included, bonuses not included. Okay, and these are the statutory requirements, right, for retrenchment benefit. EPF not payable for termination benefit. So when you look at termination benefit for EPF, right, what is not applicable for EPF? Termination benefit, notice period, annual leave. Sorry, termination benefit and notice period not applicable. There means no EPF contribution, but annual leave, yes, right? So I've given the links. You can click and brings you to EPF's website where you can see all this info. For SOCSO, termination benefit, you do not need to pay SOCSO for it, but notice period and annual leave, you got to pay SOCSO. For EIS, it's very similar to SOCSO. Termination benefit, no, but notice period, yes, annual leave, yes, right? For income tax, the tax relief given is 10,000 per year, but you got to employee, you got to make the submission. Once they approve, they give clearance, then only you pay, right? So tax relief is given for termination benefit, tax relief is given for notice period, as well as annual leave encashment. But again, all these are subject to LHDN approval. So you got to submit CP22A to get this clearance, right? So you want more info, you can click these links. Later, I'll send you the slide, or you can go to the websites of these relevant agencies and download or read up the FAQ. This is the Borang PK. So you can see the Borang PK is, you need to submit Borang PK for retrenchment exercise, VSS exercise, MSS exercise, if you're going to do a layoff, or a pay cut or salary reduction. So for all these 4 items, Borang PK need to be submitted. And Borang PK need to be submitted minimum 30 days before retrenchment, right? If you don't submit, okay, this is an outdated info. If you don't submit, the minimum fine, 50,000 ringgit, right? The minimum fine is 50,000 ringgit. Not 10,000. 10,000 was before. I forgot to update this. It's 50,000 ringgit. So please submit Borang PK before you retrench your employees. Minimum 30 days. Notify Labour Department, send the Borang PK in, and fill in all the details. And Labour Department may call you for some information, etc. Right? So I will leave this slide. These are some, some documents that Labour Department may ask you based on what has happened to some of the other organizations. Now, when should you notify Labour Department? 30 days before you retrench. Not before announcement. 30 days before you retrench. So, Borang PK, there's a few sections. Part 1, Part 2, Part 3, Part 4, and so on. So, Part 1 to Part 4, you need to submit 30 days before. Part 5, 14 days after retrenchment. And Part 6, 30 days after retrenchment. So, Borang PK has got multiple parts, right? So, this table gives you a bit of idea, but Borang PK, if you read it, is also mentioned, in the header, when to submit this, when to submit which part. Okay, now if an employee is not happy, if you retrench the employee, they are not happy, they want to file a case against you, they can IR Section 20, right? If they feel that this retrenchment is unfair to them, right? They can file a case. And this is there's one case that has gone to the court. This was in 2021, right? Ng versus Technip. Now, in this case, right, the case went to, industrial court, high court, and of course, appeal. And in this court, the Court of Appeal laid down a few principles, right? That means the Court of Appeal laid down a few principles telling companies, if you're going to retrench, right? If you're going to retrench, you must follow last in, first out. In this case, last in, first out was not followed, and the foreign employees were still there. So in this case, last in, first out not followed. Foreign employees were not terminated first, which they should, and the retrenchment was not done with a good intention. That means it is not a genuine retrenchment. So these are areas that you got to take note of in retrenching an employee. And companies cannot use financial difficulties as a reason, right? Can you use financial? Oh, we're having financial situation. Now, you must be able to prove that you are having financial difficulties, right? Now, one of the cases, I'm not sure, I don't know whether I don't think it's here, but one of the cases, the company retrenched the employee, but in that same year, the company's financial statement says profit for the year. You say retrenchment because business no good, but company made profit in the year. So it doesn't sound right. So employer must be able to present evidence they are in financial difficulties, right? They must also be able to prove they've managed to save financially. That means there's a financial saving, right? So these are some of the expectation on you as an employer if you are going to retrench an employee. So now this is another case of OI versus INTI. And here what has happened is, in this case, the employer did not furnish any evidence to show that the company has helped this employee to obtain retrenchment benefit, right? If you're going to retrench, if the business is poor, you're going to retrench, you got to notify them, right? The company also did not find any other options. If your organization is a big organization, should you not find, right? Should you not find other job? Maybe train this person up, put them elsewhere, right? So you need to find, remember this, termination is the last option, not the first option. You try everything else. Can we upskill this employee? Can we deploy them elsewhere? Can we do some restructuring? Can we look into part-time engagement? Can we look into that? Now you do all of this. Finally, if really cannot, then you retrench, right? Not taking a shortcut, straight away retrench. So retrenchment is always the final straw. So in this case, again, you can see the claimant was not offered any form of retraining or redeployment to another department, right? So all these items in bold, take note of. So if you're going to retrench, try to, avoid doing what is not proper. So this is roughly an offboarding process. If you're going to retrench an employee, make an announcement, notify labor department within 30 days, at least 30 days before the retrenchment via Borang PK, issue a retrenchment letter. Of course, you have your town hall meetings, right? Inform your employees, town hall meetings, issue a retrenchment letter, submit your CP form, right, to obtain the tax exemption, and then help your employees. Maybe tell employees, hey guys, look here, you're going to go, we're going to retrench you. Let us, train you up. So one of the clients that we assisted, the client, what they did, that some funds in HRDF, they invited us, for example, to put them through a training program, how to write resume, how to do personal grooming, how to go for interview prep, how to do financial planning. Because why? They're going to get some money, how to plan financially. So, right, you can also do this. And so what we did, we invited a few companies, come, please interview all these workers, offer them a job. So as an employer, these are your employees. They have helped you financially. They have helped you to grow your business. They worked for you. They brought in revenue. Why do you want to just chuck them and let them go? Why can't we help them, right? Tomorrow, if your business is good and you say, hey guys, do you want to come back? They may come back because they said, this is the kind of company, this is the kind of boss that I want to work for, who's so responsible, right? So complete the employment clearance process, release the salary, right? And that's it. So you can also offer a lot of onboarding support. You can do training. You can help them to prepare their resume or help them how to write resume, train them on mental health, look out for job placement. Some companies also, invite other companies to come, set up your recruitment booth. I will get my employees to come and go through an interview process. So you can do that. And of course, EIS also offers, EIS offers the so-called the insurance scheme for those who are retrenched, right? That is called a job search allowance, and it comes with free training, right? Employees will get job search allowance during the 6 months while they're looking for a job, and at the same time, they can also, undertake training provided by EIS. So, for example, the job search allowance in the first month, they will get 80% of their monthly salary, but of course it's limited to 6K. Second month 50%, third month 40%, fourth month 40%. So it goes down 80, 50, 40, 30, right? This is provided for by EIS. You're paying for it. Employees are paying for it. And these are the eligibility criteria. Malaysian citizens, of course, Malaysians pay for EIS, right? You have a contribution, unemployed, and you must submit this application within 60 days after the last day of employment. And those people who are retrenched, made redundant, VSS, MSS, company closure, business closure, etc., even constructive dismissal, resignation due to sexual harassment threats, or if they asked to do any difficult, dangerous job, they can leave, they still qualify. But of course, subject to approval by the authority. Now, before you go, I would like to just share with you, if you are going through retrenchment, so HR Forum, we are one of the training providers under EIS, and we do provide training for any of your retrenched workers on payroll management, certificate in HR, and another partner of ours, they are, they have operations management, customer service, and HR management. So these are provided for retrenched workers, as what I mentioned just now. So if you have any, talk to us. We will brief you how to go about it, talk to employees, and help and guide them. So now I'm done with my presentation. I'm a bit late because I added a couple of slides today. But just before you go, a quick announcement. So if you want to learn more on EAIR, how to do things fast, how to ensure your terminations are safe, etc., you might want to consider joining the masterclass that I run personally. This masterclass, our next session is on 15-16 April. It's a 2 days power pack program. And of course, when you join this masterclass, you get over 100 templates, policies, documentation, and so on. Here, you learn how to work smart, how to do things right, how to manage probationer, how to manage poor performer, how to manage employees with medical condition, and many other things, right? For those of you all, if you're interested, right? If you want to upskill yourself. And we also have certification programs offered by HR Forum. For example, if you're TNA, you're an L&D, you want to upskill yourself and to be a competent professional in training need analysis, we've got a CTNA program, or Certified Strategy HR Manager, Certified Payroll Professional, Certified Com and Ben, Certified HR Business Partner, Certified Recruitment Professional, or Industrial Relations Professional. All these are fully claimable from HRD Corp, offered during work hours, not weekends, not weekdays, not weekends and so on, weekdays. And we hope that this could be helpful to you if you're looking to upskill yourself as HR. Okay, so now, question time. So let me just give a minute. My team will help me to configure the screen for Q&A. So I hope you have gained as much as you can, on what and how to manage retrenchment, how do you reduce your workforce, and so forth, right? Okay, so question time. So if you have any questions, you can type in the chat box. And these slides, I will make the changes to the 2 mistakes just now. I will update this, share this in the Facebook group. Okay, so I can see the questions now. So I'm going to pick as many as I can until 4:30, right? Okay. Yep, so are we ready? Okay, so let me pick the first question. This is from YouTube. May I know what advance notice company can give? A memo? I would say as early as possible. Panasonic, for example, it is in the papers, it's nothing confidential. So Panasonic, their announcement was 1 year ahead of time, right? If your company is genuinely going through a retrenchment, business closure, downsizing, etc., you can even announce 6 months, 1 year ahead. So if you look at Panasonic, they had a scheduled retrenchment. I remember it was, it was six months or 1 year ahead of time. So it is up to you. In my opinion, the earlier you can notify employee, the better it is, right? If you're genuine about it, there's nothing to hide. So do employees, must employer reduce work hours before retrenchment and reduce entirely no overtime? Now, remember this, what we are trying to do is we are trying to save jobs. So now in order to save job, it is okay to reduce salary, reduce work hours, but you got to talk to the employee. Now, when we got into an agreement, our employment contract says that you work, you do this, I pay you 2,000 ringgit. Now, if you're going to reduce the salary, you must also get my consent. So employees' consent is important when you want to do salary reduction. So it is advisable to try every other trick or every other option you can before you retrench. Retrenchment is the last. Once the communication of the retrenchment is made, the employee is required to serve 2 months notice. During the 2 months notice period, company found an alternative position within the company. Would the retrenchment be considered null and void and the company would not be required to pay layoff? Yes. So if you have another alternative job in the company, you offer to the employee and he has got to take it, right? If you don't take it, he's at a loss. You may not need to pay termination benefit, right? Remember this, if you are given alternative employment and it fits his skills and experience, but you also must be fair to the employee. If the job that you're going to provide to him, the alternative employment, it is not relevant to the job, he can't perform, he's not skilled, he's not trained, why should he take up the job? You might terminate him later, right? Let's say now I'm a HR manager and my job, we don't need a HR manager, but there is let's say a production role, but I'm not a production guy. I do not know how to run production. I've got no production knowledge. So is it fair to put me in production? So I would say that if you're going to put an employee into another role, number one, train them up if you can, right? Provide training, provide assistance, provide support, and handhold them, guide them, etc., so that they can safely onboard and run the job. But if you're doing this just to find ways how to eventually remove him without paying termination benefit, that is wrong. Can we convert a fixed term contract employment to part-time if the company is not doing well? Talk to your employee. This has been done before. Now, you cannot force all this onto the employee. Talk to them saying that business is not so good. Are you open to the idea of us moving into a part-time employment? And this is the reduction of hours, this is the pay, etc. You see, sometimes it's all about talking. If you don't talk to them, you wouldn't know. But you cannot force it on them, right? Talk to them. Okay, maybe how long? Part-time contract, maybe for 3 months. But can I do any other job? Yes, you can. How much are you going to pay me? Okay, we reduce 40%. If you're going to reduce 50%, 60%, for the employees, he will say, how am I going to survive? So whatever that you're going to pay him under part-time employment must make sense. What if the employee don't agree with MSS? Nothing much you can do. He stays. Remember this, VSS and MSS, you cannot force them to go. If they don't agree with VSS, they don't agree with MSS, you're going to see him tomorrow morning as well. You're going to see him the next day and the following day. Do employer need to refer to rules of natural justice before retrenchment? I don't think it's a relevant question if you ask me. Natural justice applicable for disciplinary cases, right? You give a show cause letter, you give him a room to explain, you run a DI, you bring in a witness, employee can bring in witness, he can question the witness. That is principles of natural justice. But retrenchment is not a misconduct, so don't get mixed up, right? We know that MSS is mutual by employer and employee. If employer give employee less than termination benefit, is it allowed? Answer is no, right? No, the minimum, because why? You are going to terminate them using MSS route. You got to pay below. You cannot pay below. Now, first and foremost, do you think any employee, would you, Fitri, you asked this question, right? If let's say the employee, your company wants to terminate you, MSS, but the company says, can I pay you 5 days per year service? You won't accept. Why do you think another person will accept? So HR, let's be real. We got to ask ourselves, if we are being retrenched, would you accept this package? Answer is no, right? So why do you think another employee would accept? So MSS, if, in my view, if the employee accept 10 days, 15 days, 20 days per year service, you are a good negotiator, right? Better than Trump, right? Trump says he's a good negotiator. If you can do 10, 15, 20, you are a good negotiator. But in my experience, MSS, people would ask easily 1 month or even more per year of service, right? So another question, what if there's no trade union? No trade union, there's nothing to discuss with them. Talk to employees, right? If you have a trade union in the organization, you have a union, talk to the union, talk to them, notify them. Sometimes union, they can help to disseminate info, cool things down, calm the people down, etc. Explain. So that is why it is good to have a good rapport, good working relationship with your union, right? Business no good, they will understand. If you have taken good care of them, they will understand. Of course, they may have some demands, but I'm sure they can understand. They will work with you. Okay, I will talk to my employees, explain to them and whatnot, etc. Right? Okay, for employees working on project, if they have been on bench, remember I said furlough, right? They've been benched, right? No work, no work, bench. No project for them for 1 to 2 months. Can the employer terminate them on grounds of redundancy without pay? No, you still have to pay them. Any termination, retrenchment, etc., you're going to terminate them, you must pay termination benefit. But of course, remember, those people in the red box, you don't need to pay. But those people in the green box just now, you got to pay. So if you're going to, let's say an engineer earning 8,000 ringgit, right? You're now going to bench him and then you don't need him. Now he's in the red box, you don't need to pay. But if it's an operator earning 2,000 ringgit, right? 2 months, you bench them, no job. Subsequently, you retrench them. You still got to pay, right? So it does not mean that you lay off them, you put them on temporary layoff, or you furlough them. You have to pay. Could an employee agree to MSS and then file a labor case for unfair termination? Well, it has happened. I don't know who this LinkedIn user. Please join our Facebook group. I've shared a case, I think 2-3 months ago, where this has happened. Employee accepted MSS, filed the case for unfair dismissal. It can happen if you force the employee, right? You see, if it's mutual, employee is happy with their package. You tell the employee, we do not want you anymore. We are willing to offer a package. You both negotiate. He's happy with the package, right? He's happy with the package, and he takes the package. Why do you think he'll file a case? Why do you think a person who took MSS will file a case? Number one, you may have forced him. Number two, maybe he's not happy with what you pay. So he feels unfair. Maybe I'll file a case against the company, hoping that I can earn more, right? So if they're happy with it, you did not force them, the package is reasonable, they're okay with it, I don't think they'll file a case. If employer had to do mandatory retrenchment and the employee requested or insisted on VSS, MSS, to me, if it's going to be mandatory, you don't need to negotiate with them. But if you want to appreciate what they've done, they worked for you for the last 20 years, you want to appreciate, I would encourage the company, if you can afford financially, pay them more than 10, 15, 20 days, right? Like I said, in the case of Panasonic, what I've heard, they paid more than 10, 15, 20. So the law did not say you cannot pay more. The law says you cannot pay less, right? So if the employee, retrenchment, but they ask for MSS, VSS, it's up to you. But if you're going to retrench them, the minimum is 10, 15, 20. Okay, Coco Crunch. Luckily, my colleagues here are fasting, right? Okay, so there's a question from Coco Crunch. Can we use MSS cases for poor performance? Well, like I said, MSS means mutual, and we have done this before. If you find that this employee cannot perform and you don't want to put him through PIP, talk to him, saying that, dear so-and-so, your performance not so good, we do not want to keep you anymore. Are you prepared to negotiate? Are you prepared to work out a package? We have had cases where we, so-called manage them out via MSS. You can. But if he do not want to take it, if he do not want to negotiate, he do not want to take it, you cannot force it on them. It is best to just put them through PIP and manage them out. Okay, now there's a very interesting question. Is retrenchment and layoff the same thing? Almost the same thing, right? Retrenchment means they're going to go. Layoff, as if you go back and read that page just now, layoff can be for a temporary period, right? But generally, retrenchment, layoff, we refer to the same thing. You don't need them anymore. I'm going to lay you off, right? But temporary layoff is something different. Okay, when it comes to retrenchment, can the company offer the affected employee staff opportunity to accept another job position at a different branch? Yes. Remember, in your offer letter, there is a clause called transfer. The transfer clause says what? The company may transfer you to any other subsidiary or branches or whatever within Malaysia, outside Malaysia, etc. So you can transfer them. So if there's a job at another location, you can transfer them. But remember this, if the transfer is going to affect them economically, let's say, for example, I'm working in PJ, I'm in PJ right now, I'm working in PJ, my current salary is 5,000 ringgit per month. The company says, okay, we're going to close PJ branch, but I want you to go to Johor branch. And the payment for Johor branch, if you're going to go to Johor branch, I'm going to pay you 5,000 ringgit also. No change in the salary. But what about my traveling allowance, my room, accommodation, because my family is here, right? Oh, no, we cannot pay you. Now, the employee may decline the transfer because it is going to affect him economically. So if you're going to transfer an employee, please look into factors like this. Family, whether he's going to be affected. If I go to JB now, because you say I must go, if I go to JB, I earn 5,000, my up and down, because my family is in PJ, up and down, I got to pay 200 ringgit traveling allowance or maybe 300 ringgit traveling allowance every month. I have to pay a room there for 500, 800 is gone. So my take home is only 4,000 too. So this transfer will affect me financially. So therefore, I am going to politely decline the transfer. You will have that as well. Okay, Darren's, do I need to submit Borang PK to the Labour Department, VSS, less than 5 people? Even one, you got to submit, right? Even one, you have to submit. Okay. So if I have got one employee, according to MOAM, if there's only one role, one employee, and that position no longer required, can this be considered retrenchment? I mean, the right label would be redundancy. Yes, it's also retrenchment. Yes, you can do it. You retrench this person. But when you do this, right, I would be more careful. Are you very sure this person cannot be deployed or cannot be transferred, trained up, transferred into any other position, right? In one of the oil and gas company, one of these employees is a project manager. And so happened that this employee, consulted me once upon a time, and I told him this, you are a project manager. Is there any other job in the company you can do? He said, yes, I can do the job of a project supervisor. Oil and gas project supervisor, they're not paid lower, they're quite paid high, they're paid quite high. He says, I was doing this job before, and I don't mind taking a lower paying job. So he wrote to the company says no, they retrenched him. He filed a case for unfair dismissal, and his case was, I'm prepared to do the job. I don't mind a lower job. I don't mind a lower salary, but the company refused to give it to me. And this is the job I've done before. Before I got promoted as a project manager, I was a project supervisor, but they didn't want to give it to me. So finally, the company had to settle out of court because I guess they knew that their case is weak, right? So if you're going to retrench one employee, before you retrench, please see if there's any other options to deploy him. Train him up, deploy him. If all options cannot, then you retrench. Remember this, the golden rule of retrenchment. Do whatever you can to save the job. But if there's no other possible option, you have explored everything. This cannot, that cannot, you try this, all cannot. Then you retrench. So retrenchment is always the last resort, right? The last option, the last stage is retrenchment. Try everything else first. If cannot work, then you retrench. Okay, so it is already 4:30. Maybe I pick just one more question if there is. Oh, there's a lot of questions. Okay. Okay. Okay, so yeah, maybe just let me answer this question by yep. So okay, on ask this question on care. Retrenchment. Employee was retrenched. He worked with the company for 10 years. Business is closing down. He was compensated with notice period and leave encashment only. Is that lawful? Now remember this, if the employee is in the red box, he is not eligible for termination benefit. Yes, you pay notice period, annual leave, and that's it, finish. and of course, whatever salary he earned in that month. That's it, finish. But if they are in the green box, if they are earning below 4,000, if they are a manual labor earning more than 4, if they are supervising manual labor earning more than 4, for example, a production supervisor earning 7,000 ringgit, managing operators and so on, he is eligible for termination benefit. So the green box, you got to pay. The red box, you don't need to pay termination benefit, right? So once you get this slide, go back to the page with the green box, red box. I think you read it, you'll understand. But for you to understand better, join our upcoming webinar in the next, I think it's going to be next week, on EA amendment. I will run through this particular slide in detail. Right. Okay, thanks a lot for joining us today. It is 4:31. I don't want to hold you back too long. Those of you all, we are fasting. I know you need to go home early. So thank you for listening in. And I hope that this webinar has given you some idea, if it's not a lot, at least some idea how to manage retrenchment project. And if you're going to retrench now or later, please talk to us, because we have got documentation to share with you. We've got some process flow we can share with you, give you some basic guidance, no cost, no charges, right? To help you to manage your retrenchment. But if you want us to handhold you, run through A to Z, that one we got to charge you money, right? Some clients, we even submit borang PK for them. We have to charge you, right? But simple advice, talk to us, right? We've got tons of resources for company who's retrenching, from FAQ, right? FAQ for town hall meetings, the forms, the letters, right? We have all these templates available. You can also download these templates from the Facebook group, right? So thank you for listening. There's a lot of questions. I will not be able to, share so much, but it's 4:30. So thank you for listening in, and I hope it has been useful. For those colleagues who are celebrating Hari Raya, if you're fasting, happy breaking of fast, and advance Hari Raya to you. Thank you so much.
I would like to take this opportunity to thank Malaysia HR Forum for organizing this AHRP program. I'm also very thankful for the chance to meet many wonderful like-minded people here throughout the program.
Okay, so I also remember about the advice from the CEO of Malaysia HR Forum, which is Mr. Rekuma. He always says about AKS, attitude, knowledge, and skill.
So first job, don't berkira-kira, work hard. The first 10 years of your working life, and what I've said the other day, the first 10 to 15 years of working life, it's all about hard work. So first job, grab what you can first, take it up, build your experience, build your competencies, learn the skills that you don't have today. The time will come when something will tell you that it is time to move on.
So you have to remember that having qualification doesn't really guarantee you a job, but it can land you with one. But for you to continue climbing the ladder, it's all about skills. And when we talk about skills, of course, not just soft skill, communication, writing, but relates to what you're doing.
What happened between that time until now? I never quit, never lie, and I never want to be somebody other than myself. So if you're a boring person, be boring. If you're an animated person, make sure that animation comes out. And if you're a person that is shy, so be it. The moment you lie, the moment you say you know things and you don't, that's when you won't get the job. At that rate, by the time you are 30, you're going to be having a salary of 7,000 ringgit. Congratulations. But 7,000 doesn't cut it in KL. Learn, continuously improve yourself. This AHRP paper is one of them. Continue to add stuff in your CV.
As a HR professional for many years, the AHRP program, the quality of candidate that we see today, they are well equipped with the confidence, the knowledge and skills of HR, what is it to be a HR person, and all of them coming from other background.
I'm very thankful for Malaysia HR Forum by giving us this opportunity to interview some candidates that they have trained in a 5 days program, and they also filtered the candidates based on their own requirements. And I would say that this is a fresh batch of candidates for us to interview, so it was good. And in a couple of days we will shortlist some candidates and hopefully to organize a second interview with them.
When I first saw it, I thought it was a really good idea to bring candidates together with a specific specialization, which is why I wanted to participate, because I've got HR needs that I'm looking for. So it was a good platform for me to meet a good pool of candidates who have a certification that I can work with. Some of them are meeting expectations. As an organization, I'm looking more towards the ability to communicate, looking at critical thinking, character and motivation of the people. So I think for the most part, I've met good people today.
Overall, it's a good experience to participate this HR Recruitment Day. And I think it's a very meaningful event that helps the fresh graduates out there to have the employment opportunity. Overall, I find the session very fruitful, and we managed to get a few good candidates, and we are going to shortlist for the second interview with our company.